Hey everyone, I hope you're doing well. While the national conversation is understandably consumed with developments at the federal level, whether it's legislative showdowns, executive maneuvering, or ongoing debates over firearm-related provisions, it's easy to lose sight of what's still happening at the state level. The truth is, for all the headlines coming out of Washington, there are daily and deliberate efforts across state governments to chip away at the rights of lawful citizens. One such place where this fight never seems to pause is California. Over the years, it's become almost expected that gun owners there face tighter restrictions, new legislative hurdles, and a general atmosphere of state-sanctioned resistance to the Second Amendment. But once in a while, we get to talk about something different. Not just resistance, but progress. Not just another setback, but a win. And that's exactly what just happened in the Southern District of California. Let's take a closer look. Just a couple of weeks ago, on July 1st, 2025, a federal district court judge out of the Southern District of California issued a ruling that's already making waves across the country. In the case known as Hoffman versus Bonta, Judge Cathy Ann Bencivengo delivered a decision that declared California's ban on non-resident carry unconstitutional. And make no mistake, this wasn't some procedural pause or temporary injunction. This was a summary judgment, a firm, final blow against a policy that has long kept lawful Americans from exercising their rights simply because they didn't hold a California zip code. To be clear, this wasn't about concealed carry for Californians. It wasn't about permits for people who live and vote in the state. This case targeted the practice of California denying carry rights to people from out of state, regardless of whether they were trained, licensed, or legally cleared to carry elsewhere. And perhaps even more disturbing was the state's own legal argument. In court, California asserted that non-residents weren't part of the people as defined by the Constitution. You heard that right? They argued that the Constitution's protections didn't extend to individuals who don't reside in California. It's the kind of logic that should raise alarms, no matter where you live. Thankfully, the court saw right through it. Judge Bencivengo didn't just push back, she knocked the foundation out from under the entire argument. And in doing so, she opened a legal path forward that reaches well beyond California's borders. What sets Hoffman versus Bonta apart from prior cases is its breadth. We've seen legal victories before, but many were limited in scope, often narrowly applying only to named plaintiffs or members of specific organizations. One example that some of you might remember is a previous case involving California's treatment of non-resident permits, where relief was granted, but only to a select few. The impact of those decisions, while important, remained confined. This time, it's different. The court didn't just offer relief to a handful of individuals. This was a facial challenge to the entire statute, and the ruling struck it down entirely. That means the law itself, the one that blocked all non-residents from applying for a carry permit in California, is now deemed unconstitutional in its full application. The decision applies universally, not just to a small group. Even more significantly, the ruling reframes the conversation on who the people are in the context of the Second Amendment. No longer can a state argue that constitutional protections somehow disappear once you cross a border. That's a crucial precedent, not just for California, but for any state looking to enforce similarly exclusionary laws. The principle is clear: rights follow the individual, not the zip code. So, while this might feel like just another court ruling, the implications cut much deeper. It's about reaffirming that constitutional rights aren't conditional privileges. They are guarantees, and that's what this decision finally acknowledged, decisively and without caveat. Although the lawsuit originated in California, its implications ripple across state lines. By invalidating the state's ban on non-resident permits, the court has essentially put other states on notice. Such exclusions are unlikely to withstand scrutiny under the Constitution. States that adopt similar residency-based restrictions may now find themselves vulnerable to the same kind of legal challenge. This isn't just a win for non-residents hoping to visit California. It serves as a warning to lawmakers elsewhere who assume they can treat the Constitution as flexible based on residency status. The decision also reinforces the jurisprudence laid out in New York State Rifle and Pistol Association versus Bruin, where the Supreme Court held that the right to carry is not a second-class right to be denied based on arbitrary standards. Equally important is the potential shift in how courts evaluate future 2A-related cases. Hoffman builds on Bruin's framework by applying its reasoning in a concrete, statewide ban, setting a precedent that lower courts can follow. That ripple effect could redefine how Second Amendment rights are defended and enforced throughout the country. This decision reminds us that the struggle for constitutional clarity doesn't always happen in Washington. Sometimes, it unfolds quietly in district courtrooms, and in doing so, sets off a chain of consequences that can reach every corner of the nation. The message is simple but powerful. Rights denied anywhere are a concern everywhere. Now, there's been a lot of talk, some of it frustrated, some flat-out angry about how this ruling doesn't do much for Californians themselves. And I get that sentiment. If you live in the state, follow all the rules, and still have to jump through endless hoops to get a carry permit, or worse, get denied altogether, then hearing about a win for out-of-staters can feel hollow. But here's the thing. This case changes the legal terrain under everyone's feet. By affirming that the state can't limit rights based on residency, the ruling chips away at the legal logic California uses to justify all kinds of carry restrictions. If the Constitution protects non-residents from unfair treatment, then what does that say about the ever-changing county-based schemes used against residents? How defensible are those drawn-out delays, arbitrary denials, or inconsistent standards? This case doesn't directly rewrite California's permit system for residents, but it does hand future challengers a powerful tool. It lays a constitutional foundation that could make it much harder for the state to justify any licensing process that discriminates by geography, wealth, or bureaucratic whim. That's not just theory, that's strategy. So, while this decision might not unlock the door for Californians overnight, it certainly cracks the frame. It opens up new lines of argument and new opportunities to dismantle the structures that restrict lawful carry from within. If you live in California, this isn't the finish line, but it's a starting point that matters. Predictably, California's legislature isn't sitting still. As court rulings begin to loosen the state's grip, lawmakers are already working to tighten it again, this time through Assembly Bill 1078. You may have heard bits and pieces about this one. Most attention so far has gone to its proposal limiting gun purchases to 3 per month, an apparent response to previous court decisions striking down the 1-a-month restriction. But tucked deep in the bill is something just as important: a new framework for non-resident carry. Here's how it works. If passed, AB 1078 would formally legalize permits for non-residents, but under the state's full control. That means extensive requirements, psychological evaluations, live fire training, mandatory fees, county-specific declarations, and expiration after only a few years. In short, the same red tape that's frustrated residents for decades would now be extended to everyone else. On paper, this might seem like a concession. In practice, it's a preemptive move designed to neutralize the very court rulings that prompted it. By legislating a pathway, however restrictive, California could argue that judicial intervention is no longer necessary. And that's a problem. If this bill passes, it risks making the recent legal victories irrelevant. Worse, it allows the state to shift the debate from "is this law constitutional?" to "we already addressed that." It's not a fix, it's a redirect, a way to keep the machinery of control running, just under new branding. That's why AB 1078 demands close attention. It's not just legislation, it's resistance in legislative form. Let's keep it real. This ruling isn't constitutional carry. It doesn't erase the permitting process. It doesn't force California to recognize other states' carry permits. And it certainly doesn't mean we've reached the end of the fight. What it does offer, though, is a moment of clarity in a long, messy legal battle. A moment where the court stood up and said, "No, you can't exclude people from their rights just because they live on the other side of a state line." But even with that step forward, we're still dealing with a patchwork of laws that shift wildly from one jurisdiction to another. That's why so many people are looking beyond the courts and toward federal action. The idea of national reciprocity, or a legislative mandate protecting carry rights across all 50 states, isn't new. But rulings like Hoffman could reignite that conversation with fresh urgency. For those hoping to see broader change, this case should serve as a rallying point, not a resting place. Whether through Congress or the Supreme Court, the ultimate goal has to be a recognition that rights are not conditional and do not require state-by-state negotiation. Federal clarity would mean fewer court battles, less confusion, and stronger protections for law-abiding Americans regardless of where they live or travel. So, while we celebrate what this decision represents, we also need to stay grounded. It's a chapter, not the conclusion. The fight for national-level recognition of carry rights is still very much ahead. No ruling exists in a vacuum. Over the past few weeks, the feedback from gun owners across the country, especially those in California, has been unfiltered and passionate. Some see this as a step in the right direction. Others dismiss it outright, calling it a meaningless gesture for residents who still face enormous obstacles just to exercise their basic rights. And then there are those somewhere in the middle, glad to see movement, but tired of symbolic victories. These reactions matter. They remind us that the Second Amendment community is not a monolith. There are business owners concerned with self-defense in high-risk areas. There are veterans frustrated by bureaucratic hoops. There are everyday people who just want equal footing, no matter their zip code. And for many, victories like this don't feel like a win unless they come with immediate, practical impact. But here's the reality. Long-term change often unfolds in slow, frustrating increments. Legal wins, especially those that challenge deep-rooted policies, rarely come with instant gratification. They set the groundwork, they shift the burden, and eventually, they create the space for something larger to take hold. The skepticism from within the community isn't something to ignore. It's something to understand and respond to. That means doubling down on transparency, continuing to challenge unjust laws, and most importantly, not mistaking this ruling for a cure-all. It's a signal, one that says the wall is starting to crack, but not yet crumbling. This ruling opens a door, but it doesn't dictate what comes next. That responsibility now falls to those willing to step through and keep pushing. Legal victories like this one can't exist in isolation. They require follow-through. That means more litigation, smarter challenges, and pressure where it matters, in courts, legislatures, and public opinion. There's already movement on that front. Advocacy groups are watching how this decision can be used to challenge other licensing schemes within California. Attorneys are reevaluating how they approach cases involving arbitrary denials or drawn-out approval processes, and residents are beginning to understand how this ruling can support their own claims for equal treatment under the law. Still, the danger is always the same, that lawmakers pivot quickly to reassert control under a different name. That's why each policy revision, each bill like AB 1078, needs to be viewed with skepticism and analyzed down to the comma. Because nothing passed in haste or in reaction to court losses tends to favor liberty. To move forward, we need more than one-off wins. We need persistence. Every lawsuit that follows this one should point back to the same principle, that rights are not a privilege of residency, class, or county. They belong to every American equally. The next steps won't be glamorous. They rarely are, but they matter. Because what follows a win like this is what decides whether it becomes precedent or just a footnote. Wins like this don't come often, especially in places like California. It's not everything we've been fighting for, and it won't fix the broader system, but it's movement in the right direction, and that matters. Each decision that chips away at unconstitutional restrictions lays groundwork for something bigger. It may feel small now, but momentum builds case by case, line by line. If this breakdown helped clarify the situation or got you thinking, feel free to share your thoughts below. Your voice pushes the conversation forward. Stay informed, stay principled. Rights don't defend themselves.